Good afternoon, good morning, everyone. My name is Matt Kissling. I am a partner in Thompson Hine's Labor and Employment Practice Group, and welcome to today's webinar. Today we'll be discussing legal and practical considerations to guide workforce decisions, including layoffs, furloughs, and reductions in force in uncertain economic times. We'll also be touching upon how certain workforce changes can impact union requirements, immigration concerns, and certain benefits considerations. We'll discuss how to navigate these challenges and minimize or mitigate potential risk. Before we begin, I just want to address a few housekeeping items. First, today's program is being recorded, and a link will be sent to all attendees over the next couple of days. This presentation is also intended for the general information of individuals and organizations on matters of current interest. Thoughts and opinions being expressed today are those of the individual presenters only and do not necessarily reflect the opinions of clients, employers, affiliates, or Thompson Hine as a law firm. The content should not be taken as advice, as the views expressed are for informational purposes only. Please feel free to use the question box located in the control panel on the right side of your screen to submit any questions. We'll try to answer as many of the questions as we can during and after the webinar as time permits. If we do not have enough time to answer all questions, then we will be following up with you individually via email after the presentation ends today. In the related content section, you may also download the PowerPoint slides as well as the bios for our speakers here today. I'm pleased to be joined today by partner Sarah Flannery, as well as our managing associate Janae Jean-Baptiste, who are both from our Cleveland office. And we're also joined by Katie Kohn, who's a partner in our benefits practice group, who is joining us from our Washington, D.C. office today. So again, thank you for your interest, and I will be kicking things off here today. We're going to be discussing planning workforce reductions to mitigate legal risk. So I always feel it's helpful to start with asking the big question: what exactly is a furlough, a layoff, or a reduction in force, and what are the differences? So starting, what is a furlough? A furlough is generally a mandatory temporary unpaid leave of absence from work. This is a situation where the employment relationship is not severed or terminated, and there's generally an expectation of return to work. Now, often we see furloughs arise in cases involving seasonal operations or seasonal work, or situations where there are government mandated shutdowns or stop work. So a good example would be the federal government shutdown back in October and November caused a number of different furlough situations for government contractors. Now, a layoff is a little bit different. Here, a layoff involves a formal separation from employment for the impacted employees. And this can, again, be due to lack of work or funding or loss of client relationships. The important different characteristic here is, again, as the employment relationship formally ends and the employee is offboarded from the organization. So that's when final paycheck requirements or any other state separation requirements are triggered. And a layoff can be temporary or permanent in nature, but generally there's no guarantee that an employee will be returned if they're laid off. Now, a reduction in force is similar to a layoff, but it tends to be more in a group setting. So a reduction in force typically involves the permanent elimination of one or more positions within a workforce, and usually there's no intent to replace the eliminated positions. Now, we often see RIFs arise in corporate restructuring situations or economic-driven headcount reductions or somewhat similar situations impacting an organization. So let's talk about the legal side of things. What are some common legal claims that we often see arise in any sort of a workforce reduction? So it really does present a minefield of potential legal issues. We often see claims under the Age Discrimination in Employment Act or a state law equivalent, which this law generally prohibits discrimination on the basis of age and requires additional information that needs to be provided to individuals who are over the age of 40 if you're going to obtain a effective and enforceable release of age-based claims. We also see claims under other discrimination laws such as Title VII, the Americans with Disabilities Act, and their state law or local law equivalents, which generally prohibit employment decisions which could have a disparate impact on a protected class, where you have criteria that's facially neutral, but for one reason or another, it excludes out a certain protected group of employees over others. From a notification perspective, we often see claims arise under the Federal WARN Act, as well as similar state notification laws, which we'll be touching upon in more detail as we go through the webinar today. And again, as with any other separation issue, we can see claims under state wage and hour laws, where these laws can establish specific requirements for final paychecks, including what to include in the timing, as well as additional separation notice requirements for employees. Now, other laws not listed here where we can see issues arise are under the National Labor Relations Act, which Janae is going to be diving into more detail here today. We also see issues under COBRA or other benefits laws, and then if you have offer sponsorship or have employees on visas, there are certain immigration related legal issues that can arise. So again, a number of different areas where we can run into legal claims and legal issues. So how can we mitigate risk? So there are really a number of different best practices that we're going to be discussing here today. And it starts with determining the basis and parameters for the layoff, RIF, or other reduction. So what exactly does that mean? So it starts with establishing the need. And this is really asking ourselves, from a planning perspective, what's the objective that we're trying to achieve here? Why are we talking about reducing our workforce? Is it a financial motivation? Is it to save money by reducing headcount? Have we experienced a loss of customers or business, whether it's company-wide or impacting a specific function or department? Is it due to a consolidation of operations? Can we do the same level of work with less headcount or less facilities? And so these are often the situations where we see the need for a layoff or RIF arise, but there are certainly other circumstances that could justify or necessitate a reduction in force. So once we establish the need, then what do? We should talk about the scope. And this is really looking at what are the locations, the departments, functional areas where potential reductions are needed. Are we talking about at one location or across the company? Are we talking about just one department or across multiple functional areas? What's really important to do here is to document and articulate and explain why a particular location or functional area has been identified, because this is all going to proving and justifying that our decision-making process is supported by legitimate business justifications, that there's no improper considerations coming into play. Another part of determining the scope is also setting the overall goals of the reduction. Are we looking at eliminating third shift production or some other kind of across the board change that we're planning to make? And going along with that, it's always helpful to outline what the impacted areas will look like after the changes. What positions are being eliminated, what are being combined, things along those lines. It's really formalizing a before and after picture of what the reduction and results will look like, and that can really help us formulate an effective parameters or scope of the reductions overall. So another thing we should be thinking about is confirm the type of reduction. So a workforce reduction can take a number of different forms, whether it's voluntary separation program, involuntary cuts, or a combination. If we're looking at voluntary process, these are often the first stage of a workforce reduction. Really what a VSP does is it gives employees individually the opportunity to self-select and leave the company in exchange for certain separation benefits. Now, the upshot of a voluntary program is this could have less of an impact on employee morale, as well as reduce the risk of liability or claims against the company, because again, employees are being given the opportunity to self-select themselves for separation in exchange for benefits. Potential downside is that as the employer, we may be relinquishing control over who ultimately participates. So this could lead to a higher number of yes decisions from employees than we originally expected, or on the flip side, not enough employees elect to self-select to participate and leave the organization. So again, these potential downfalls again highlight the importance of really being proactive and careful and specific in identifying the scope of what we're trying to achieve here. And what about an involuntary reduction? This tends to be the more common form of a RIF or a layoff situation that we see, which, as the name implies, this is where the company is selecting who is going to be impacted or selected for reduction. Now, an involuntary process can be used to supplement a voluntary program. Let's say you didn't have enough employees self-select, or you just skip the voluntary aspect entirely and simply pursue an involuntary process. And the advantage for us as employers is that an involuntary reduction gives us more control over the selection process, since we can identify who's going to be selected and excluded and who's going to stay on board. Involuntary process is also often faster to implement, but it does come with the greater potential risk and often leads to questions about the who and the why when it comes to selection decision making, and can lead to increased legal scrutiny or potential legal claims. So, given those risks, if we're going through an involuntary process, it's important that we establish and apply uniform selection criteria for the process. So this tends to be the most critical factor in whenever we're carrying out a successful and defensible reduction, particularly if it's involuntary. Now, the criteria can be objective, such as looking at years of service or seniority, disciplinary history. It can also be subjective, such as performance rankings that may be dictated by individual supervisors or decision makers, or it can be a combination of the criteria. We often see multiple types of criteria being used, and employers establishing a ranking or a tiered system for deciding who to select. Now, what's important whenever we're establishing this criteria is that who are the decision makers that we're going to be relying on, and do they understand how to apply our criteria? Having uniform criteria doesn't do us any good if people don't know how to apply it and do so in a consistent manner. So it really kind of raises two important points. First, it's important to be thoughtful when we're selecting who is going to be a decision maker for the reduction. Are they someone who can make the informed selection decisions, are qualified to and are in a qualified position to do so, and are credible whenever in terms of who they select versus do not select. It's also important to provide training or instruction to the decision makers on what our criteria is, and here's how the company expects us to apply it. And like any employment decision, it's critical that we document the decision-making process and the criteria selection, because that's going to be our first line of defense if we have to justify why we made a particular selection decision as part of the overall reduction process. After we've made the preliminary selections, what should we be doing next? We should complete a risk assessment. So this involves two different steps in the process. First, it's important that we review all selection decisions. And really, the idea here is we're looking at each individual selection, a partnership between HR and either inside or outside legal, and it's really looking at each decision maker's selections to make sure that the criteria is being properly applied and that's validated against an employee's personnel file, performance documents, or other relevant materials. And so really the question that we're trying to answer here is, does this person actually fit within the criteria? So if we're using performance rating as a basis to select, is this selected person actually one of the lower performers compared to others in their particular group? It's also important to make sure we're complying with our process for the reduction program. So when we're setting the parameters or the scope, are those processes being followed? And finally, it's looking at, do the decisions themselves make common sense? So, in terms of who's been selected, are we potentially opening up operational holes that were not intended as part of the reduction program? And if the answer is yes, do we then need to revisit who was selected versus non-selected? Going along with that, do we also need to look at, do any of our selections pose a legal risk? Are any of the employees on some form of protected leave, such as FMLA, military leave, or other protected leave? Have any of the selected individuals, recently raised, claims or complaints related to discrimination or other employment issues? Has there been any sort of organizing activity that an employee has been participating in? So it's really trying to look ahead to see, are there any of these legal minefields that we may be stepping into, by selecting one person for participation in the reduction process. So it's also important that we look at the data itself. And this is really looking at the overall selection decisions compared to the overall group of people being considered. Because in addition to kind of traditional disparate treatment claims, both federal and state discrimination laws also prohibit facially neutral decisions which have a quote-unquote disparate impact on employees in protected classes. And an effective adverse impact analysis that we conduct will serve to identify whether any selection decisions will have that disproportionate impact on one protected group of employees over another's. Again, this allows us as employers to identify and resolve and get in front of any disparities that may exist. So really think of it this way. It's really a sneak peek of what a government agency like the EEOC or a plaintiff's lawyer may be looking at and analyzing if they were to get their hands on the selection information and the selection data. And then again, the advantage is it allows us to get out in front of it and take appropriate mitigating steps before the potential issue comes to the surface. So what is an adverse impact analysis? What should it look like? So again, an effective analysis should evaluate decisions in multiple different ways. It should look at our overall selection decisions versus those who are broken out by decisional units, whether it's by location, department, or supervisor. And it's really asking the question, how do we group our decisions together if we were asked by the EEOC or a state civil rights agency? Generally, an adverse impact analysis looks at crunches the data in two different ways. The generally accepted rules are the 80% rule, which is usually kind of the initial threshold for statistical significance, and followed up by the standard deviation rule or standard deviation test, which if it triggers the 80% rule, standard deviation test will then confirm whether or not it is statistically significant. So if a decision hits on both rules, that tells us statistically there may be an issue that we need to probe deeper and look back into the decision-making process. So what if a problem is identified? What are some things we should be thinking about and asking ourselves? Again, it tells us we need to take a deeper dive. So again, first and foremost, can we validate that each selection decision was properly based on the neutral selection criteria? So that goes back to the phase one of the risk assessment. Looking at the criteria itself, was there any particular criteria that may be causing the disparate impact? If the answer is yes, do we need to take a shift and rely on different criteria when selecting individuals? And then going along with that, do we need to reconsider any individual selection decisions going along with the particular criteria that have been used? Okay, so we've talked about risk assessments and planning the workforce reduction. What else should we be thinking about? So great way to potentially mitigate risk of legal action is offering severance in exchange for a separation agreement. So really two initial questions we need to ask ourselves is first, do we currently have a severance policy or program that will apply? Is there something in our handbook? Do we have a formal severance program that's going to apply this to this situation? Because that'll dictate then what the severance looks like and what if any conditions we can tie to an employee receiving severance. If we don't have that type of program in place, the next question is, do you want to offer severance or other separation benefits to impacted employees? And if so, what conditions do we want to attach to it? So what are the advantages of offering severance? So most obviously, mitigates legal risk by securing enforceable releases of legal claims from the impacted employees. This is particularly important if you have folks who fall within certain protected classes or unprotected leaves or things along those lines. And generally in this situation, an employee may lose the financial incentive to pursue a claim with the EEOC or other legal claims any further. It can also establish goodwill and assist employees in their transition from the company. And finally, if you have other employee obligations that you want to reinforce, it gives us an avenue for doing so in an agreement, such as restrictive covenants, return of property, or even post-separation cooperation by the employee. Now, what are the potential downsides of a severance program? Obviously, if you're going to be paying people, it increases the cost. So is providing severance consistent with a financially driven layoff or a reduction in force? It could open the door for individual negotiation, because of some of the language that needs to be in a separation agreement. This could cause individual employees to lawyer up or try to use potential claims as leverage to get additional severance. For individuals in protected age classes, there may be required enhanced disclosures for those individuals. We typically call the OWBPA disclosures. And there may also be additional burdens on you as the employer to ensure compliant and enforceable releases, particularly under state law. So our recommendation, typically is that if you're going to give severance to impacted employees, use a release. It's a give and a take. You're given a benefit in exchange for the release. And depending on, where an employee is located, you may have two different sets of releases at a minimum for what we call under 40 and over 40. That number may tick up if you have employees spread across multiple different states that have their own unique requirements. Now, from an OWBPA perspective, here's a list of what the typical requirements are to secure a valid release of age discrimination claims. They must specifically refer to rights and claims under the ADA. You must advise the employee right to consult an attorney and give them the opportunity to do so. Depending on the situation, for individual terminations, they need to have at least 21 days to decide whether to sign. That goes up to 45 days if we're separating multiple people at once or as part of the same decision-making process. After they sign, they must be given 7 days to revoke their signatures before the agreement becomes effective. And again, the agreement needs to be supported by additional consideration beyond what the employee is already entitled to receive under company policy or program. For group terminations, which tend to be our 2 or more employees being impacted, the age-related releases also need to describe, again, the decisional unit for the separation program, provide information about what eligibility factors or criteria were used for selection, as well as the time limits of the separation program, the start and end dates. What are the job titles and ages of all employees in the decisional unit that have been selected, and then what are the job titles and ages for all employees in that same unit that were not selected for separation. Again, these are requirements that need to go into separation agreements for anyone who is age 40 or older. And again, they're required to secure an effective and enforceable release of age claims. If that wasn't fun enough, what about state law? So again, I mentioned before, state laws can have their own unique requirements for separation agreements. Some good examples are California, where they have a mandatory Civil Code Section 1542 disclosure, which relates to releases of claims that are not known to an employee at the time that they've signed the agreement. You have friends in the state of Colorado, where they have their new Power Act that was signed in 2023 that severely restricts the situations where an employer can put confidentiality or non-disclosure provisions in a separation agreement. Basically, the non-disclosure needs to be mutual, and all parties need to sign an addendum to the agreement that specifically certifies compliance with the Power Act's requirements. And then in Illinois, they have the Illinois Workplace Transparency Act notifications and consideration requirements that apply regardless of an employee's age. And generally here, the confidentiality and non-disclosure needs to be mutual and needs to be the employee's preference. And the IWTA also imposes a 21-day review and consideration timeline regardless of an employee's age. So a lot of things to think about, when we're planning a reduction in force, from a severance and structure and risk mitigation perspective. I'm going to turn it over to Janae, who's going to talk about what are things we need to be thinking about from a union in labor relations perspective. So Janae.
Thanks, Matt. And as Matt mentioned, I'm going to go into some of the best practices for the notice that you need to provide and also bargaining requirements. But before I do that, it's important to note that it's best to review the current collective bargaining agreement for provisions that includes management rights, severance, notice procedures, and also waivers, as these provisions can shape and sometimes satisfy bargaining obligations. And I also like to note that the NLRA distinguishes between bargaining over the decision to implement a reduction in force and bargaining over the effects of that decision. The general rule is that decisions that directly affect wages or other terms and conditions of employment can be mandatory subjects of bargaining. However, not all business decisions triggers the obligation to bargain. For example, under Supreme Court precedent, an employer's decision to partially close for economic reasons is typically not a mandatory subject of bargaining. Still, the employer must bargain over the effects of that decision. Now, whether the decision itself is subject to bargaining depends on the nature of the change. Where the decision turns primarily on labor costs and does not change the scope or direction of the enterprise, bargaining over the actual decision is more likely required. On the contrary, where the decision is rooted in entrepreneur control, such as a fundamental relocation of the business or operational reconfiguration, effects only bargaining would apply. However, there's a defense here if if in fact there is a clear and unmistakable waiver established by the language of the contract, or there is a consistent past practice where the employer can show that they have in the past implemented certain similar decisions without bargaining, but the employer still must provide notice and bargaining over the effects upon request. Now, I want to talk a little bit more about effects bargaining. The important thing here is that it's always required when employees are adversely affected, even if the decision itself is not subject to bargaining. The requirement there is that the employer must bargain in good faith over the effects. And what are the effects? That is the timing, the actual severance, the selection criteria that Matt mentioned earlier. It may also include recall rights or benefit continuation, things of that nature. And then in terms of the timing, it is critical that companies provide advance notice and a meaningful opportunity to bargain before implementing a reduction in force or a layoff where feasible. If not, you run the risk of an unfair labor practice finding. And if that happens, the remedies for the failure to bargain may include an employer being responsible for back pay, which can be very costly depending on the size of the layoff or the reduction in force. And then this slide just pretty much includes an overview of the notice and bargaining process. As I mentioned earlier, it includes providing notice to the union. You want to make sure that it is prompt. It's a written notice that includes the scope, the timing, also the reason, and provides the opportunity to meet and bargain. The next step is to actually bargain till you reach an agreement or a lawful impasse. And this part is key because a premature impasse declaration can constitute grounds for unfair labor practice charge. So you want to make sure that there is an actual lawful impasse. With respect to midterm bargaining, if the CBA applies, whether midterm bargaining is required depends on the contract's waiver or reservation. If there's not a clear waiver, then bargaining may be required. And again, the effects bargaining topics is what you want to focus on. And again, that includes a number of different things, and I won't list them all here because I mentioned them, but these are sort of the things that you want to focus on in terms of bargaining over the effects of that decision to implement a reduction in force or a layoff. And this slide focuses on the things that employers want to stay clear of, and that is unilateral changes on mandatory subjects of bargaining. Because if you do so, you can run the risk of violating Section 8A5 of the National Labor Relations Act. You also want to stay clear of directly dealing with employees concerning this decision. Everything should go through the union. And then the other main thing that I really want to emphasize here, because a lot of employers will assert that there is some sort of financial or economic reason for the reduction in force. And while that defense is available, there are certain obligations that comes with it. And it's a very narrow defense that you have to be very careful about. And we'll talk about it in the next slide. And so if an employer asserts some sort of financial necessity or financial reason for the layoff or reduction in force, the union may request supporting information, and the employers will be obligated to provide relevant non-privileged information needed for bargaining. Now, the employer does have the right to assert confidentiality and require certain accommodations, such as like an NDA. But it has to be able to articulate that in a manner that allows the union to review that and evaluate that. And I want to also point out that there is a distinction between the inability to pay and also competitive disadvantage. When an employer is closer to a competitive disadvantage, it has less of an obligation to disclose its financial records versus just simply asserting that there is an inability to pay. And another aspect of the reduction in force issues that you want to be careful of is during any merger or acquisition transactions, because during those transactions, they can trigger recognition and bargaining obligations for the new employer. So you want to be sure that you conduct a thorough due diligence review of any contractual obligations prior to that, so you can get in front of it and not run the risk of any unfair labor practice charges with the board. All right, and so I want to take a moment just to go through some of the comment pitfalls. As I mentioned earlier, I tend to see employers having some trouble with overstating exigent circumstances based on ordinary economic pressures because of that high obligation that comes with it of having to the duty to furnish their financial records. So you want to be careful not to overstate that. The other thing here is you want to make sure that you provide the relevant information necessary for bargaining. And as I mentioned earlier, do not deal directly with the employees. Instead, let everything go through the union so you can ensure that there isn't any misunderstanding as to what the employer's position is. And then the big one here is that fulfillment of the WARN notice does not satisfy the National Labor Relations bargaining duties and vice versa. So it's best to keep the two separate and ensure that you're complying with both. And here are a couple key takeaways. I know this was pretty quick, but this is high level. And as I believe my partner, Katie, mentioned, all of these slides will be circulated after. So if there's any specific information that you wanted to follow up on, it will be made available to you after this webinar. But I want to leave you with a few practical steps to follow, and that is to audit the CBA. Take the time to identify any management rights, seniority or severance provisions that can help govern or control sort of how you handle a reduction in force. You also want to be careful to define the business rationale, documenting legitimate reasons for the decision. And then the next step would be to draft a notice to the union to provide them with the timing and also the details, the selection criteria, and provide an invitation to bargain. And then you want to make sure you're prepared for the bargaining session, and that is identify the negotiables and to identify areas where you may have to provide information related to the bargaining session. And then most importantly, I would recommend that you train your managers to prevent them from direct dealing or making any coercive statements, and to centralize communications through HR. And finally, you want to ensure that you're preserving all bargaining notes. And so I think with these few practical steps, you would be in good position to handle a reduction in force with respect to any of the labor or notice obligations under the National Labor Relations Act. And with that, I'm going to pass it to Sarah Flannery, who will talk with you about the immigration aspect of things.
Thanks, Janae. Some special considerations that have to be taken into account if one of the workers who would be undergoing a termination or a layoff will be in play if they are on a work-sponsored visa. The first consideration is a 60-day grace period. The immigration regulations allow a grace period of 60 days for individuals who are here in the U.S. on a work visa, and those include E1, E2, E3, H1B, which is perhaps the most common, H1B1, L1, O1, and TN. So if an individual is working for a company under one of those employer-sponsored work visas and their employment is terminated, they will be considered to still be maintaining their status, even though that is tied to the employment. So normally they're only considered to be maintaining their status if they continue to work for the employer that sponsored them for the work visa. But that maintenance of status will continue for 60 days, so long as they at least have 60 days left on their approval period. If they have something less on their approval period, they don't get the full 60 days. So for instance, if you had an H-1B worker whose authorization is going to expire in March of 2026, and you lay them off, terminate their employment in February of 2026, they do not have a full 60-day grace period because they don't have a full 60 days left on their authorization. They will have a grace period only so long as from the date of termination out through the expiration of their status. The purpose behind the grace period is to allow that individual to either find alternative sponsorship with another employer that might be able to sponsor them for the work visa in that 60-day period, or for them to consider another status that they might be eligible for and request a change of status, or to simply wrap up affairs here in the U.S. before exiting. The 60-day grace period is triggered when the employment ends. A lot of times what will happen in these situations is the worker with the employer-sponsored visa will ask the employer, can we make that 60-day grace period longer by allowing me to first have an unpaid leave of absence and then push out my termination date? Because the 60-day grace period is only triggered when there is the termination of employment. Going on an unpaid leave of absence does not constitute failing to maintain status, and it does not trigger the 60-day grace period. Before employers would grant those requests to foreign nationals, I would suggest speaking with employment counsel because it could be creating a risk for an employment discrimination claim. If you are terminating the employment of a large group of individuals, that includes both U.S. citizens, permanent residents, and some foreign nationals with work authorized visas, and you say to the foreign nationals with the work authorized visa, we will give you a 30-day leave of absence beginning now, and then we will push out your termination date out longer than the others in the group so that you have a longer runway. Are you extending a benefit to that foreign national employee that you're not extending to the U.S. workers? So that's something that should be guided by employment counsel, but I just want to raise it as something that is often commonly presented from foreign national employees to employers when they learn that their employment is going to be terminated. H-1B workers and O-1 workers have an additional obligation that the employer needs to offer them return transportation to their country of citizenship. The way that this would be relayed to the associate is, we are terminating your employment before your period of stay expires. If you elect to leave the U.S. because you do not find an alternative sponsor or you are not eligible for an alternative status, we will provide you a check for the amount of a one-way coach class ticket to your country of citizenship. If they're going to stay in the U.S., you don't have to provide the return transportation. And we usually suggest language that says if you are going to depart and you want the return transportation, you need to alert us by 45 days after the termination, and then we will get you a check by day 60. And you just look at maybe 3 commercial airline flights to their country of citizenship, find an average, and that's the amount that you give them. They can then book the flight. If it's less than what you gave them, they are able to retain that amount of money. If it's more, they have to pay the additional amount. Another consideration that needs to be at play if there is a layoff and the company is also sponsoring foreign national workers for a green card is what is the impact that that layoff would have on the sponsorship for those other employees. So you may have associates within the company that you're sponsoring for permanent residency. They currently hold a temporary work visa. Maybe those individuals are not directly impacted by the layoff at all, meaning that they're not within the scope of employees whose employment will be terminated. However, the layoff occurring could impact their green card sponsorship. If a company is at the stage of green card sponsorship where they are testing the U.S. labor market to show a lack of U.S. workers, and there has been a layoff in the same occupation that your foreign national being sponsored for is in, you need to go to those employees who are laid off, who are U.S. workers, and see if they're qualified for the role that you're sponsoring your foreign national for. So this is really just like right hand and left hand within a company needing to make sure that they're coordinating, because again, it doesn't only get triggered if the foreign national who is being sponsored is in the layoff group. It's just if there is a layoff in the same occupation that they are in, then it could have an impact on their green card sponsorship. That concludes the points that are specific to foreign national sponsorship. And I will now turn it over to Katie Kohn to discuss benefits.
Thanks, Sarah. So this is not intended to be exhaustive overview of benefits issues when in respect of RIFs or layoffs, but I am going to hit the high points. And of course, if you have any questions, just feel free to reach out or put them in the chat box. Okay, so with 401k defined contribution plans, I'll just say 401k, but this also, most of these rules apply to other types of defined contribution plans. A participant's status is updated to terminated, and that has a number of impacts with respect to the 401k plan. So the participant usually becomes eligible to take a distribution, or their benefit is subject to force out if it's below the force out limit, which can be up to $7,000. The participant's eligibility for employer contributions, such as employer match or non-elective contributions, could be impacted. And then also that I'll go out of order a little bit, that last bullet regarding required minimum distributions. For folks that work past the required beginning date, which is age 75 right now, 73 right now, their required minimum distributions kick in once they've terminated. So they have to start RMDs the April 1st after that year. And all of this so the participant's status should automatically update through payroll in communication with the record keeper. But if you have widespread layoffs or a RIF, it's a good opportunity and reminder to check your plan document and how your plan is being administered to make sure that everything is working correctly. So for instance, with match contributions or non-elective contributions, it's a super common error in plan administration to have those being calculated incorrectly. Maybe the match determination period isn't correct, or the non-elective determination period isn't correct. So it's a good opportunity, again, to just double check. If your plan allows for loans, then any outstanding loans of participants who are terminated will generally become due once they are terminated. You have to check your plan document to see what it says, but most plan documents do provide for that. So participants need to understand what they need to do to repay those outstanding balances. And even if your plan document doesn't provide for automatic acceleration of the loan coming due, because participants generally have loan repayments deducted from their paychecks, there could be a default that occurs just because they're no longer receiving paychecks. So again, check with your record keeper and ensure the participant understands his or her requirements and options with respect to loan repayment. And this is important because if a loan defaults, the outstanding amount of the loan is treated as a distribution, and the participant will be taxed and potentially penalized with a 10% early withdrawal penalty if they're below age 59 and a half. Defined benefit pension plans have the same issues with respect to termination, the terminated status of an employee. So in many instances, participants will become eligible for to take their benefit, either to commence their benefit or to receive a lump sum distribution. And so these points on this slide aren't necessarily unique to RIFs or layoffs, but when there are RIFs or layoffs, sometimes that correlates with financial distress of a company, and sometimes that correlates with funding issues with a pension plan. So there are certain funding-based restrictions for benefits, for lump sum benefits and any other accelerated form of benefits, such as Social Security leveling options. So just double check with your actuary to ensure that the benefit funding, that the funding level is sufficient to pay out things like lump sum benefits. Contingent benefits, such as plant shutdown benefits, in my experience, they're not super common anymore. This is more of an old school type of benefit, but they definitely still exist. So check your plan document to make sure that there aren't any plant shutdown benefits. And those also have funding-based benefit restrictions. So again, check with your actuary on any funding-based restrictions that may apply. Moving to regulatory reporting. So PBGC has a reportable event obligation with respect to a bunch of things, but active participant reduction is one of the reportable events that often occur with more widespread layoffs. So there's an active participant reduction if greater than 20% of the active plan participants are separated from employment. And that is compared to the number of actives at the beginning of the plan year. So this could happen as a result of a single event, like a single mass layoff or single RIF, or it could happen over the course of a plan year. So that's called an attrition event. So unless there are reporting waivers that apply, and there are a lot of reporting waivers, so check with Benefits Counsel as to the applicability of any of those, but generally plan administrators are required to notify PBGC 30 days after active participant reduction, and there are some advanced reporting obligations as well. Partial plan terminations are presumed to have, and this applies both to the DC and defined benefit plans, partial plan terminations are presumed to occur when there's turnover of greater than 20% of active participants. This is a fact-intensive inquiry, and this is just a presumption that can be overcome. So you can look at, normal turnover and whether certain separations are truly employer initiated. But if you have a partial plan termination, the consequence is that affected employees, and that's a loaded term and not specifically defined in the statute, but affected employees are become 100% vested. So you need to make sure that people that are affected by a partial plan termination are 100% vested. That often means that people who have separated and have been forfeited benefits, those benefits need to be reinstated. And it can get a little tricky if people have already taken their benefit from, like a 401k plan. They've taken their distribution. You have to reinstate those amounts and then, go find the person and make sure that they get the rest of their money. I also find that partial plan terminations are easily missed by companies. And so this is definitely something to keep an eye out for if you are going through more widespread layoffs. All right, moving to the health and welfare plans. It's important to understand when employees' coverage lapses. So normally, in my experience, the coverage will lapse at the end of the month in which employment ends, but it could be on the date employment ends. If there's a desire to continue benefits for folks that are furloughed and not completely laid off or completely separated, that can be an option. You just need to, one, check with the insurers to make sure that they can accommodate that, and then check your plan document to make sure that if it needs to be amended, amend it, or and then if there's an amendment, update the summary plan description or send an SMM. And then, of course, confirm with the employees the claims run-out period for any claims that have been incurred before termination but are submitted after termination. COBRA, continuation coverage obligations, are definitely something to keep on top of. Of course, we need to provide COBRA coverage or offer COBRA coverage to anyone who loses coverage as a result of termination. And there's all kinds of other COBRA qualifying events. So again, this is not an in-depth COBRA discussion. But when it relates to layoffs and RIFs, typically the COBRA qualifying event will be termination of employment. And that gives the COBRA beneficiaries a right to elect COBRA coverage, generally for 18 months, although that could be extended for a variety of reasons. The employer generally has 30 days to notify the plan administrator of the health plan of the qualifying event, so like a termination. And then the plan administrator has 14 days to notify the qualified beneficiaries of the COBRA right. And so for plans that are administered in-house, that gives you 44 days to notify participants of their right to elect COBRA. For any deficient or late COBRA notices, the penalties can be up to $110 per day. And there's been a lot of litigation in this area in the past decade. Some decision points on COBRA. So will the employer subsidize COBRA? If so, make sure it's clear how long and to what extent the subsidy will last. And if the employer has a self-funded plan, just be on the lookout for potential non-discrimination issues. For health FSA and then HRA plans, typically those amounts are forfeited, definitely for the FSA, but the HRA, there may be a spend down period or a run out period depending on plan design. But to the extent that a participant elects COBRA, they will still have access to those benefits. And then for life, voluntary benefits confirm when coverage ends for life and AD&D and any conversion rights. And then for voluntary benefits, confirm portability and the payment options so that those benefits can continue. And in the interest of time, I would love to talk about multi-employer plans. If you have a multi-employer plan, you're going through a RIF, I highly suggest just contact me or your benefits counsel after to talk about the unique issues that can come with participating in a multi-employer plan. But I want to turn it back to Matt because I know he has a few more topics to cover before we end.
Thank you, Katie. So I know we're running up on the top of the hour. We'll probably be going a few minutes past 1 o'clock Eastern today. So love it if you are able to remain with us for the remaining discussion today. Okay, so we've talked a lot about the planning considerations for a workforce reduction. Let's talk a little bit more about the implementation, and specifically, what do we need to do to comply with federal and state law related to notification and offboarding employees. So it starts with everyone's favorite topic, the Federal WARN Act. So a federal WARN requires covered employers to provide at least 60 days advance written notice to employees in certain government agencies in the event of a qualifying plant closing or mass layoff. Now, the notice requirements under federal WARN are very specific for whenever you have a triggering event. So it starts with the question, who actually is an employer for purposes of WARN? So under federal WARN, you're going to be covered if you employ 100 or more employees, excluding part-time employees, across your entire organization, or if you have 100 or more employees who in the aggregate work at least 4,000 hours per week, excluding overtime. Thing to remember here is that, differentiating between a full-time employee and a part-time employee. So for purposes of WARN, a part-time employee is someone who is employed for an average of less than 20 hours per week, or they've been employed fewer than 6 of the 12 months prior to the date on which notice is required. So if your company policy, says someone is part-time if they work 30 hours or less, they may still need to be counted for purposes of WARN if you face a potential triggering event. So what exactly is a plant closing? So as the name implies, a plant closing is the either permanent or temporary shutdown of a single site of employment or one or more operating units within a single site of employment. And then to trigger WARN, the shutdown needs to result in at least 50 full-time employees suffering a covered employment loss at the employment site. So one thing to note here about what exactly is a single site of employment is that first you do need to consider remote employees who may not physically work at the facility, but who either report into the location or receive their assignments from the location. If they fall within those buckets, then the remote employees need to be included with anyone who works on site. Another thing to note about the single site of employment, it can either be a single facility or a group of buildings that are either on the same campus or within a close proximity to each other that share staff and are generally used for the same or similar business purpose. So what is a mass layoff? We're not talking about an entire facility closure. So this is a reduction in our total active workforce at a single site of employment that's not due to a plant closing. So typically a mass layoff exists if we have at least 500 employees at the employment site who experience a qualifying employment loss, or we have at least 50 employees at the site that experience an employment loss, and those 50 employees make up at least 33% of the total workforce at the site. So a good example would be, let's say you have 120 total employees at the site and you're laying off 50 of them, that's going to be considered a mass layoff for purposes of WARN. So WARN is not required in every situation for an impacted employee. It has to be a qualifying employment loss for purposes of WARN. This occurs in one of three circumstances. First, if there's an employment termination other than a termination for cause, a voluntary departure, or a retirement. So usually voluntary leavers do not count. Similarly, if you terminate someone for performance-related issues or violating company policy and it's for cause, that's not going to count as an employment loss either. Employment loss also exists if you have layoffs that exceed 6 months, or in a furlough situation, usually if you have a reduction in work hours of more than 50% during each month of a 6-month period. So if you furlough employees for 6 months due to a government shutdown, that's going to be a WARN qualifying situation as well. So WARN does have a few odd rules for purposes of counting employees to determine if the numbers are triggered. So they have both a 30 and a 90-day period that where you have to look at who's being impacted. So a 30-day rule says you need to determine the total number of qualifying employment losses that occur in any rolling 30-day period. So let's say on day number 1, you lay off 30 employees, and then 25 days later, you lay off an additional 20 employees. taken together, if those 50 employees are at least 33% of the workforce at that location, that's going to be a warrant triggering event, and all 50 employees then need to receive the 60-day notice. The 90-day rule is a little trickier to apply. What this rule says is if you have two or more groups who suffer employment losses within 90 days, and neither group alone is large enough to trigger warrant, then the groups will be aggregated together to trigger warrant. This is a 90-day look ahead and look back period from each individual employment loss. So it's sometimes helpful to visualize here. So let's say on day number 1, we have 100 employees. Day number 2, we lay off 30. Day number 32, we lay off 15 employees. And then day number 60, we lay off an additional 5 employees. So there are total within that 60-day period of 50 employees who are laid off. In this situation, all 50 employees are entitled to warrant notice because while each of the 3 buckets did not independently trigger warrant, taken together within the 90-day period, that they would satisfy warrant's requirements and represented 50% of the workforce. And so they're all part of the same layoff program. They're all entitled to 60 days warrant notice. So let's say warrant is triggered. Who exactly needs to receive notice? So generally, it's 4 different groups. First, all affected employees need to receive warrant notice. And these are individuals who are reasonably expected to experience an employment loss. So they've been selected based on the neutral criteria that we've identified. If it's a union covered location, the notice needs to be given to the chief elected officer of the union or the bargaining representative. And as Janae mentioned, providing warrant notice is not a substitute for any other obligations under the CBA or affects bargaining requirements. I need to provide notification to the state government. This is usually the state dislocated a worker unit for the state in which the layoff or the plant closing will occur. Most states have what they call a rapid response unit that's designated to receive the warrant notice. And then you also need to provide notice to your chief local official for the government where the layoff or closing is going to occur, whether this is a county executive or a mayor of the city where the facility is located. So what needs to be included in the notice? As I mentioned previously, the notice requirements are very specific. So all 4 of the notified parties need to be informed of, need to be provided a statement of whether the planned action is expected to be permanent or temporary. If the entire facility is going to be closed, need to provide a statement to that effect. We need to provide a statement of whether any sort of bumping rights exist. This typically applies in a union environment. And then we need to provide the name and telephone number of whoever our designated company official is, to answer any questions or provide more information about the layoff or the closure. So what else needs to be provided? So affected employees, in addition to those items, they also need to provide on an individual basis the expected date of when the closing and the layoff will begin, and then the individual's expected termination date. This can either be a specific date, or warrant also requires you to provide a 14-day window when their expected termination may occur. If it's a union environment, you need to provide the representative with the expected date of the first termination and the anticipated schedule for making separations, as well as a list of all job titles affected and the names of the employees currently holding those job titles. And then for the state or local government, our notices need to include information about the name and address of the employment site where the closing and the layoffs can occur, the expected date of the first termination, and the schedule for making separations, the list of job titles affected and the number of affected employees in each job title, and then if applicable, the name of the that chief union official who has also received notice. So I saw that there was a question in the chat box. What happens if we don't provide warrant notice? So failure to comply with federal warrant, it can lead to civil liability to the affected employees for both back pay and the monetary equivalent of employment benefits for each day of the violation, up to and including 60 days. So 60 days is the maximum. But generally the penalty will be whatever the gap is between 0 and 60. And employers can also face civil penalties of up to $500 per day if you fail to provide notice to the local government official. So now there are a few limited exceptions to more notice requirements. And again, I want to emphasize these are the exceptions, not the norm, and the burden is on you as the employer to prove that one applies. The first one is the faltering company exception. This only applies in plant closing situations, and here you need to show that we've been actively seeking capital and that providing more notice would somehow preclude our ability to get the capital to keep the facility open. It's a very limited exception. The next is the unforeseeable business circumstances exception, which tends to be the most common one we see applied. And this requires us to show that due to business circumstances, it was not reasonably foreseeable for us to provide 60 days advance notice. So a good example would have been during the COVID era, when there were the state shutdown orders that came overnight. That would have likely qualified as an unforeseeable business circumstances exception. More recently, the federal government shut down. And then the final example is the natural disaster exception, where this is where natural disasters such as a tornado, flood, or other event causes the plant closing or the mass layoff. Again, important thing to remember: these are exceptions, not the norm to warn requirements. Now, we often see companies ask us, can't we just provide pay? 60 days of pay in lieu of notice. And while federal warrant does not recognize any exception for providing pay, instead of the mandatory notice, the thing to remember is since the maximum liability to an individual employee is up to 60 days of back pay and benefits, we provide them with that full pay and benefits for any violation period. That effectively precludes the relief for the individual impacted employees. But what we need to remember is that this pay in lieu of notice, does need to be voluntary and unconditional. It cannot be tied to a severance agreement. So if you're also going to offer severance, that would be in addition to the 60 days in lieu of notice pay. And even if we provide that pay, we can still remain liable for civil penalties if we fail to provide notice to the unit of local government. So if federal law wasn't fun thing to worry about, there are also what we call state mini warrant laws. So in addition to federal warrant, there are at least 15 states that have some form of mini warrant laws that are on the books that often go above and beyond the federal requirements. So the most recent one to join the ballgame was Ohio, where our mini warrant law took effect on September 29th of last year, but other states include California, Illinois, Massachusetts, New Jersey, New York, and Washington. Some of the common features of these mini warrant laws include lower thresholds for employer coverage, such as less than 100 employees. A good example would be New York's mini warrant law applies if you have at least 50 employees working in New York State. There may be different triggers for the notice requirements. Again, looking to New York, and they consider a qualifying mass layoff or plant closing to occur if it impacts at least 25 employees as opposed to 50. And a lot of states also have enhanced notice requirements, such as longer notice periods. Some states require 90 days notice as opposed to 60. Different contents of the notice. A good example would be Ohio says you have to provide a detailed statement of the reason for the layoff or the plant closing, as well as information regarding available support for the impacted employees and information about their unemployment rights. And there may also be additional parties you have to notify. These often include, in addition to providing notice to the city, providing notice to the chief elected official of the county government. And some states require you to provide notification to the school district, the local workforce development board, or even the police, fire, and EMS departments for the location. So it's highlights the importance of being aware of how these state mini warrant laws may be different from federal warrant. Even though we have states that aren't necessarily mini warrant laws, there are other states that have additional requirements for employers who are otherwise covered by federal warrant. A good example here is Minnesota, where state law requires employers covered by federal warrant to provide the state dislocated worker unit with a list of the names, addresses, and occupations of employees affected by the triggering event. So not just the job titles and the number of employees each, you need to provide the names and contact information for each of those individuals. If that wasn't fun enough, to wrap us up here today, let's say we're implementing the plant closing or the reductions. What are some final state law considerations on top of warrant notice we need to be thinking about? So final paychecks. It's a common area where we always see claims or issues arise. So are we clear on the timing of the paychecks? Do they need to be issued on the day of, the next payroll date, a different schedule? What must be included in the final paycheck? Is it just unpaid hourly wages or salary, or do we need to include bonuses or commissions? Is there an obligation to pay out unused vacation or paid time off? And then how do we need to issue the final paycheck? Can we do it via direct deposit, or do we actually need to cut paper checks? These are all things we need to be looking at, depending on the states where the impacted employees are located. And some states, in addition to warn, also have their own separation notice requirements. And so the question we need to ask, who needs to receive it, and what must the notices include? A good example would be the state of Georgia they have a specific form they have to provide to each individual employee at the time of separation. That it contains information about the reason for separation as well as their own employment rights. So just a few final points before we wrap up today. What are some of the other termination basics that we want to make sure we're taking into consideration, even in a group separation environment? So first, we're talking about communicating the decision. We always recommend developing a set of talking points for the discussion. So they tend to be objective points, and really get to the point and explain the decision in somewhat detail. And it's important we make sure the employee then understands what's the path forward for them, when are they leaving the company, and what's going to happen next. It's always important that we make sure that people having these discussions are prepared to answer questions relating to benefits, outplacement services, severance benefits. Is there a potential for transfer or rehire, as well as, how does the company handle employment references or unemployment claims? The other things to think about do we have employees who are under restrictive covenants? It's important we make sure to remind employees of their continuing obligations from a restrictive covenant perspective. And again, if you're providing severance, this is always a good opportunity to put something into the release agreement. The same with return of company property. Do we have an established process to ensure the complete and timely return of company property, equipment or files? And then finally, from a announcement communication perspective, when the cat's out of the bag, how are we going to announce the decisions internally to other employees or locations that may not be impacted? And it's always important to be ready to answer questions or concerns from those other groups of employees. So it's establishing a central communication and a designated official for folks to go to if they have any questions or concerns. The same goes with third-party communications. That this is going to become public knowledge, so it's important we establish a procedure for communications to customers, vendors, and business partners, as well as any sort of media or other external inquiries. Again, establishing a point of contact for this is who you refer people to if you're getting questions from any of these third parties. So I know that was a lot of information condensed into slightly over an hour, but I think some of the biggest takeaway here is just emphasizing the importance of establishing our process and really taking into consideration all the different planning and legal considerations for a workforce reduction, whether it's furloughs, layoffs, or a reduction in force. And by doing so, it will go a long way to making sure we're delivering and implementing an effective workforce reduction, as well as mitigating potential legal complications. So that concludes our webinar here today. I know we received a number of questions in the chat box. We apologize for going a bit over the 1 o'clock hour. Since we are over time, we'll be responding to each individual who submitted a question individually via email over the coming days. And so we'd like to thank you all for attending our webinar here today. If you're currently not receiving our updates and invitations to similar webinars or other events, we invite you to go to the Thompson Hine website and register to receive our mailings under the Publications tab, or you can reach out to your designated Thompson Hine contact, and we'll make sure you get on the appropriate distribution list. And then if you have any other questions or concerns, or if we can be of help in any way, here's our contact information. So again, we thank you all for your interest in attending today's webinar. Copies of the slides will be sent out within the next 48 hours. We hope that you enjoy the rest of your day and that you stay well. And thank you for attending.